Hi, folks. This is Dr. Brogdon. We're going to be talking about the treaty power and federal supremacy today. We're going to cover a couple of cases, Missouri versus Holland, Reid versus Covert, which are going to get to the heart of a really important question, which is, are there really any limits to the treaty power? Congress is authorized to carry into execution all of its enumerated powers and all other powers vested by the Constitution in the government or in any department or officer of the government. You'll remember that phrase from Article 1, Section 8, the Necessary and Proper Clause. And the president is empowered to make treaties by and with the advice and consent of the Senate. And we put that together with a provision over in Article 6 in the Supremacy Clause that tells us that treaties are the supreme law of the land. That leaves us with the question, are there any limits to the kinds of treaties that the president with the Senate can make? And then are there any limits to Congress's power to carry those into execution? Those are very important questions because normally whenever we consider the powers of Congress, we're talking about an institution with enumerated powers, or more precisely with delegated powers, and those powers are to some extent listed or laid out in the Constitution. If, though, the president can make treaties on any subject, notwithstanding the enumerated powers of Congress, and then Congress can enforce them, then this is in essence a backdoor way of making laws about things that Congress ordinarily couldn't regulate, that normally would go beyond the scope of federal powers. It's a very important question. So let's climb into the case law and look at these couple of cases. We're going to take a look first at Missouri versus Holland, a case that's nearly 100 years old now, but is still good law, still cited on the treaty power, even though there have been some recent controversy about just how to apply this case and the extent to which it still holds. But you see it here. Missouri versus Holland involved the Migratory Bird Treaty. This was a treaty with Great Britain, which really it was a treaty with Canada, but of course Canada is in 1920 a part of the British Dominion. But the Migratory Bird Treaty controlled the killing, the hunting and capture of animals, particularly of birds that might cross our borders, that migrated from Canada to the United States. And this laid limitations on the ability of states to permit the killing of birds covered by the Migratory Bird Treaty. Now, Congress had passed a law already several years prior to this treaty that accomplished the same thing. That is, Congress had forbidden the killing of migratory birds and imposed a federal regulatory scheme that set aside the way that the states went about doing this. And federal courts found some constitutional problems with that statute, in part because they couldn't find warrant in the Constitution for Congress regulating the domestic hunting of animals. And as here, Missouri has a law by which they permit their citizens to kill within the regulatory framework of the state, to hunt and kill certain birds and other wildlife. After the initial act ran into judicial resistance because of the constitutional problems, the president determined to solve the problem by enacting or entering into a treaty with Great Britain to accomplish the same aims that Congress's act had accomplished. Another way of saying this is Congress was unable to regulate within the Constitution the subject matter of the treaty, at least at the time. And so the president determined to make a treaty to confer that power on Congress. And indeed, that's what they did. The Migratory Bird Treaty Act of 1918 is an act carrying into effect the 1916 treaty between the United States and Great Britain. Now, the court here hears a challenge to this law, and you have the issue put pretty clearly before them. Here's an enactment that just a few years before had been found to be unconstitutional, and the only thing that has changed is that there's now a treaty in place that might authorize Congress to regulate the matter. So you see here from Justice Oliver Wendell Holmes Jr. Writes the opinion in this case. It's very brief, very pithy opinion. In a lot of ways, you'll see there are a number of passages in the opinion that are worth taking note of and that have worn pretty well. But you'll see here at the top of page 91 in your packet, Justice Holmes tells us, if the treaty is valid, there can be no dispute about the validity of the statute under Article 1, Section 8 as a necessary and proper means to execute the powers of government. So, in essence, what Justice Holmes is saying is that the validity of treaties has no relation to the content of Article 1, Section 8. That is the enumerated powers laid out in that provision of the Constitution. And in fact, we could, if we swap over to our copy of the Constitution for just a moment, and we look over here in Article 1, Section 8, we'll recall that there we find Congress's powers enumerated. The Congress shall have power to, and we have a long list of things that they can do, as you can see, to borrow money, regulate commerce, etc., all the way down to the necessary and proper clause, to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. So Justice Holmes is telling us that essentially where the enforcement of a treaty fits is not here at the beginning of the necessary and proper clause where it says to make all laws which shall be necessary and proper for carrying into execution the foregoing powers. That provision's pointing back to the enumeration of Congress's powers in Article 1, Section 8. But instead what he's saying is that it fits into this next provision, to all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. That means that the treaty power, which is, if we scroll on down to Article 2, we'll see is among the president's powers, that the president shall have power by and with the advice and consent of the Senate to make treaties, provided 2/3 of the senators present concur. That's a separate power conferred on the president. And according to Justice Holmes, when we look at Article 1, Section 8, that's part of those all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. In this case, that department being the executive department and the presidency, together with the Senate. So in this way, the treaty power escapes the doctrine of enumerated powers. It escapes this limitation on the government, the requirement that Congress only regulate, that it only legislate pursuant to its enumerated powers, to the things listed. So we've seen that. So let's go back for just a moment to Justice Holmes's opinion and see what else he has to say. Now, he points to one other provision of the Constitution that's extraordinarily important here. He says, acts of Congress are the supreme law of the land only when made in pursuance of the Constitution, while treaties are declared to be so when made under the authority of the United States. So let's go look at that provision for a moment. In Article 6, the Supremacy Clause, he's pointing to a subtle difference in this provision. Now, the Supremacy Clause, you'll remember, declares federal law to be the supreme law of the land, and tells us that the judges in every state are bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. So this is telling us that where there's a conflict between federal law and state law, the federal law wins out, the state law gives way. But he's focusing on this initial part, which tells us just exactly what is the content of federal law. And there's an important phrase here. This Constitution and the laws of the United States which shall be made in pursuance thereof. So to make a law in pursuance of the Constitution is to make that law in a way that's in conformity with the Constitution. This suggests that there's a way to make a law that's not in pursuance of the Constitution. So if Congress were to make a law touching on a subject over which Congress has no power, or which violated constitutional rights under the Constitution, that would be a law not in pursuance of the Constitution, but in violation of the Constitution, or in excess of Congress's powers under the Constitution. And what Justice Holmes points to is the fact that when the Supremacy Clause speaks of treaties, it speaks of them differently. You note the made in pursuance thereof is attached to laws of the United States, which shall be made in pursuance thereof. Then we have another category of federal law, and all treaties made or which shall be made under the authority of the United States. So Justice Holmes is reading a lot into the selective use of the phrase made in pursuance thereof. He says that phrase is only attached to laws of the United States, that is, laws passed by Congress, ordinary legislation, and not to treaties. So that in order for a law of the United States to be the supreme law, it must be made in pursuance of the Constitution. But in order for a treaty to be part of the supreme law, it only must be made under the authority of the United States. So any treaty that the United States enters into. And he suggests that this is a textual recognition that in this provision, the framers of the Constitution are laying down a distinction, that Congress, in the exercise of its regulatory power, is limited by the doctrine of delegated powers, but that in the exercise of the treaty power, the President and the Senate are not so limited. They can make treaties on any subject. And Justice Holmes consoles us over this to some extent. He tells us we must realize that when we're talking about a constituent act like the Constitution of the United States, and I'm reading here at the end of the left-hand column, we must realize that they have called into life a being, the development of which could not have been foreseen completely by the most gifted of its begetters. It was enough for them to realize or to hope that they had created an organism. It has taken a century and has cost their successors much sweat and blood to prove that they created a nation. This is a bit of an aside, but just to point out, Justice Holmes, writing in 1920 here, this is an important nod to progressive thinking at the time. In particular, Woodrow Wilson, as well as Teddy Roosevelt, but mainly Woodrow Wilson, had really pointed quite vigorously to a distinction. He said that the framers of the Constitution thought in Newtonian terms about their Constitution. That is, they conceived of it in terms of physics, in terms of a machine that operated by fixed laws. And he said, in fact, that was a flawed way to think about government. Instead, we should think about constitutions, and indeed governments generally, in terms of biology. We should think of them as organisms, so that when we think about the development of a constitution or the development of government, we think of growth, not of the operation of a machine that operates consistently by fixed rules, but instead like an organism that grows and in ways that can't be foreseen. You can see here the sort of kernel or the sort of heart of the dispute between advocates of a fixed meaning in the Constitution and advocates of a living Constitution. This is really a nice encapsulated description of the living Constitution view in a way. Yet it is interesting that despite saying that, Justice Holmes does feel the compunction to point to the text of the Constitution. That is, he points to this distinction in the necessary and proper clause in Article 1, Section 8, that maybe not in the detail that we've treated it, and he points to that subtle distinction in the Supremacy clause in the use of the phrase made in pursuance thereof attached to the laws. So he does lean quite heavily on the text and find lots of evidence there. Find some ground for this view. Now, there's one last point that Justice Holmes makes here. He says the treaty in question does not contravene any prohibitory words to be found in the Constitution. Now, so far we've been talking about whether the treaty confers power on Congress that Congress does not have as part of its delegated powers. Here, Justice Holmes switches gears and he says, alternatively, that the treaty doesn't contravene any prohibitory words. That is, you can think of this like a thou shalt not. And in fact, you can see this distinction in the Constitution itself. If we go back up to Article 1, Section 8, you note how that begins. The Congress shall have power. And you see that's sort of a thou shalt. It's conferring power on Congress. If you look at Article 1, Section 9, though, we see prohibitions. For example, the migration or importation of such persons, any of the states now existing shall think proper to admit, shall not be prohibited by Congress. So we get a thou shalt not whenever we get to Section 9. And note, this continues. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of rebellion or invasion. No tax or duty shall be laid on articles exported from any state. So the prohibitory language of Article 1, Section 9 in the original Constitution contrasts with the proscriptive language of Article 1, Section 8. That is, Article 1, Section 8 authorizes Congress to do certain things, whereas Article 1, Section 9 forbids or prohibits Congress from doing a number of things. And of course, that's followed by Article 1, Section 10, which lays a number of prohibitions on states, tells states, thou shalt not. No state shall enter into any treaty, etc. So Justice Holmes is suggesting then, in his opinion that the treaty does not contravene any prohibitory words. That is, that suggests without saying that that even were a treaty to touch on a subject that Congress could regulate, that still couldn't violate a prohibition in the Constitution. It couldn't suspend habeas corpus unless in case of rebellion or insurrection. It couldn't violate free speech or freedom of the press or the right to keep and bear arms or any of the other prohibitory words in the Constitution, any of the limits, the express limits on governmental power. But another way of saying this, if we think about it, is that the case asks the question, may Congress exercise a power under a treaty that it could not exercise in absence of that treaty? Or is the treaty power limited by the doctrine of delegated powers? And Justice Holmes's answer to this is, yes, Congress can exercise power under treaty. It could not exercise in absence of the treaty. The treaty power does not, is not limited by the doctrine of delegated powers, but then that results in a qualification. What he suggests here is that treaties may not transgress constitutional prohibitions, like, as we said, things that are contained in the Bill of Rights and other such things. Now, there's a second case I want to look at. The Missouri versus Holland case has been taken has been taken as a largely as warrant for the position laid out here in the little sticky, the top of the page. But throughout the 20th century, there have been a number of challenges to that broad view of the treaty power. One of those came in Reid versus Covert, 1957. Of course, this grows out of the proliferation of U.S. military installations around the world. In this case, one case growing out of an Air Force base in England and an Army base in Japan. And here you had the wives of military personnel. Both of these are women who had killed their husbands. Both of them are presenting an insanity defense, which at the time was not permitted in a military courts martial. So both of these women are convicted, and they're convicted by courts martial. They're convicted by a panel of military officers without the benefit of jury trial, without the benefit of other provisions of the Bill of Rights, other due process protections that U.S. citizens are normally afforded. Now, the reason that this case is important for the treaty power is that the government claimed that there was, and you can see this on page 94 in the right-hand column, at the time of Mrs. Covert's alleged offense, this is the woman who had killed her husband in England, an executive agreement was in effect between the U.S. and Great Britain. And that agreement permitted U.S. military courts to have exclusive jurisdiction over offenses committed in Great Britain by American servicemen or their dependents. But at the same time, it obligated U.S. military courts to prosecute those persons for any violation of British law. So the argument was that the foreign relations power, the treaty power of the United States, as well as the commander-in-chief power, and so forth, authorized an extraordinary measure. That extraordinary measure being subjecting the spouse of American military service persons to trial by courts martial. Now, the court here confronts head-on the question that Justice Holmes had only suggested. Remember, Justice Holmes had suggested for us back in Missouri versus Holland that perhaps any prohibitory words in the Constitution might limit the exercise of the treaty power, even where the enumerated powers of Congress didn't impose any limitation. Here we get that question put very directly. And the question is phrased this way. The court says at the beginning, we reject the idea that when the United States acts against citizens abroad, it can do so free of the Bill of Rights. The United States is entirely a creature of the Constitution. Its power and authority have no other source. It can only act in accordance with all the limitations imposed by the Constitution. So you see here, for one, in this opinion by Justice Black, you can see a very emphatic affirmation of the constitutional character of all governmental powers in the United States. That is, that there is no power that any institution in the U.S. government exercises that's not conferred on it by the Constitution. All of those powers, the war powers and so forth, even the most extraordinary powers, are exercised by those who hold them because they're conferred on them by the Constitution. Now, that might raise a question. If that's the case, then doesn't the Constitution constrain the exercise of those powers through enumerated powers? And indeed, you can see some language in Justice Black's opinion which seems to push back a bit against what Justice Holmes had said nearly 40 years earlier in Missouri versus Holland. You can see here Justice Black tells us the obvious and decisive answer is that no agreement with a foreign nation can confer power on the Congress or on any other branch of the government which is free from the restraints of the Constitution. And then he cites the Supremacy Clause. What he's getting at here in citing the Supremacy Clause is the same distinction. The government actually raised the argument that this subtle difference between that we've already noted in the Supremacy Clause, where laws are only the supreme law if made in pursuance of the Constitution, but treaties are the supreme law as long as they're made under the authority of the United States. Justice Black tells us there's nothing in this language that intimates that treaties and laws enacted pursuant to them do not have to comply with the provisions of the Constitution. In other words, he seems to be pushing back against the idea that we should treat treaties, forgive the redundancy, that we should consider treaties differently than laws when deciding their legitimacy under the Supremacy Clause. He says this: these debates, as well as the history that surrounds the adoption of the treaty provision in Article 6, make it clear that the reason treaties were not limited to those made in pursuance of the Constitution was so that agreements made by the United States under the Articles of Confederation, including the important peace treaties which concluded the Revolutionary War, would remain in effect. This deserves a little bit of discussion. Justice Holmes had suggested that inclusion, the selective use of the phrase made in pursuance thereof and applied to laws of the United States, was intended there to limit the scope of ordinary laws, but to leave the scope of the treaty power unlimited. Justice Black points out, and this is borne out if we take a look at the debates and the framing of the Constitution and the framing of this language in the Federal Convention, it was a concern that if such language was applied to treaties, people might insist that existing treaties that the Continental Congress, prior to the creation of the Constitution, so for example, the Treaty of Peace with Great Britain and with France from 1783 that ended the Revolutionary War, would have to be re-ratified. That we'd have to renegotiate those treaties, that any treaty that was put in place prior to the ratification of the Constitution would become illegitimate because those treaties were not made in pursuance of the Constitution. So this is why the made in pursuance thereof language is omitted with the Treaties Clause, and instead we see made under the authority of the United States. Of course, the United States had had an existence since 1774, arguably. Since the first Continental Congress had described itself as the United Colonies. And certainly since 1776, where the Declaration actually refers to the United States. And of course, the Articles of Confederation explicitly called the government of the Union the government of the United States of America. So this is Justice Black's way of pointing to an alternative reason for the selective use of the phrase made in pursuance thereof in the Supremacy Clause, and one that doesn't necessarily mean that treaties are unlimited, that they're not subject to enumerated powers. Where you would expect him to go with this next is to say, so Missouri versus Holland is a questionable precedent, and we should consider setting it aside, or at least consider it to be on shaky ground, or render it an unreliable precedent. But he doesn't. In fact, he goes to great lengths toward the end of his opinion to say there's nothing in Missouri versus Holland which is contrary to the position taken here. He's very, very careful to say that he's not setting aside or overturning Missouri versus Holland, but is preserving that case as a precedent. And he says, there the court carefully noted that the treaty involved was not inconsistent with any specific provision of the Constitution. The court was concerned with the 10th Amendment, which reserves to the states or the people all power not delegated to the national government. Again, their delegated powers. And he says, to the extent that the United States can validly make treaties, the people in the states have delegated their power to the national government, and the 10th Amendment is no barrier. So Justice Black, by the end, takes what would seem to be the identical position that Justice Holmes took. Now, the difference between them is Justice Black's opinion provides at least some basis, a textual basis, for saying that no, treaties cannot confer power on Congress that Congress doesn't have in absence of those treaties. If Congress can't pass a law, or if some subject is beyond the control of Congress, then you can't add those powers to Congress simply by entering into an agreement with a foreign government. Um, you've seen this occur in recent years, and in fact, one might ask, what's the big deal? Um, what kinds of actions are we talking about here? We're talking about migratory birds, um, but is that really the extent of the problem? Well, you can see some of the potential problem in Reid versus Covert. That is, when the government starts looking around and making agreements with foreign governments about the way that it conducts criminal prosecutions. You could imagine a treaty obligation that subjected, and um, this should ring some bells. A treaty obligation that subjected U.S. citizens to trial before an international tribunal, and perhaps one that doesn't afford all the same protections as the Bill of Rights. Could they do that? Arguably not. Or there are some other provisions too, or some other things we might think about. Imagine a subject that was taken to be beyond Congress's ordinary control. Um, the content of elementary education, something of that kind. Um, and there was an agreement with a foreign government that obligated us to alter what we teach in classrooms. So that Congress could then say, well, we agreed as part of an international agreement to ensure that elementary school children learn sex education. Um, and would that then provide Congress with an entree to enter into that area? You could cook up all kinds of sort of dystopian scenarios where you think some place where, one would start from the position that surely Congress can't regulate that, and then imagine a treaty that in fact obligated Congress to regulate it, and suddenly Congress derived its powers from the treaty. Another way to think about this is, if it actually works this way, treaties could be taken to be um, uh, a sort of hidden source uh, of authority for Congress. That is, it looks like Congress has enumerated powers, but really all you need is a treaty to add to that list, so that a treaty touching on a new subject, childbearing, education, environmental concerns, um, another great example, um, touching on religion or some other subject that one normally doesn't consider Congress to be concerned with. Um, and imagine Congress furnishing, or imagine the presidency and the Senate furnishing Congress with that authority simply by entering into a foreign agreement. So that's sort of the fear. That's the reason that this is taken so seriously by many people, and why its critics take it so seriously. On the flip side, the other argument is, if you'll notice, a lot of the instances that I've mentioned so far have involved some kind of violation of rights. Um, whether it be parental rights, or whether it be free exercise rights or free speech. One issue that used to be much more of an issue was the question of gun possession. Congress was not regarded as having a general regulatory power over gun possession, only over interstate commerce in firearms. And things touching on interstate commerce, and one could imagine a treaty provision that obligated the federal government um, to enter into a scheme of firearms confiscation. And this was, quite often a sort of scenario that people would think of. Of course, that's been largely cut off by the fact that the Supreme Court has construed the Second Amendment as an individual right. And so that, of course, under Reid versus Covert and Missouri versus Holland, means that while the federal government could conceivably confer power on Congress over firearms by entering into an international agreement to that effect, it could not transgress the Second Amendment in any way. That is, it couldn't transgress the prohibitory terms of the Constitution or those prohibitions on the exercise of power in the Constitution. So that's in a way sort of the balance that's been struck by the court. Now, the exception to this, there was a case quite recently. If we look, Bond versus United States, decided just a few years ago in 2013, which involved the application of the Chemical Weapons Convention. The Chemical Weapons Convention being an international agreement about the use of chemical weapons in chemical warfare. And Congress implemented that treaty, that international agreement, through an Implementation Act in 1998. And it criminalized the possession or use of chemical weapons. Now, this particular case, somewhat humorous. I'd suggest you go look it up and see what was going on. In fact, this would be a good way to spend a little bit of your time. And what remains today is to go check out the SCOTUS blog page on this and some of the debate, some of the SCOTUS blog coverage and the arguments, sort of the editorials and back and forth that were published on it. Because it's kind of funny. Miss Bond had actually attempted to poison her husband's mistress. Not what you would normally consider conduct covered by an international chemical weapons convention. But indeed, that was how the federal government applied it. The U.S. attorney brought charges and indicted her in federal court for violation of the Chemical Weapons Convention. She challenged the law. The court kind of backed out of it. This was an opportunity for the court to say, no, Congress can't use a chemical weapons treaty, which seems pretty innocent on its face, to then go about prosecuting, I think Justice Alito asked in oral argument in this case, if chocolate is poisonous for dogs and I give my dog chocolate, have I violated the Chemical Weapons Convention? And interestingly, the argument of the government in the case was possibly yes, you may have. So they were willing to construe this quite broadly. But the court wound up deciding unanimously that not that it was unconstitutional for Congress to do this, but that in fact the Chemical Weapons Convention Implementation Act was only aimed at preventing the use of chemical weapons, not attempting to poison your spouse's mistress, but instead the things that you would normally regard in the terrorism, international arms dealing, and things of that kind. In any case, it's a pretty interesting case to go look up and kind of illustrate some of the question with this. But the court ducked. The court didn't say anything about the constitutional status of the treaty power, though some of the concurring opinions did want to go back and revisit Missouri versus Holland and clarify and say, no, if a treaty extends Congress's powers down to, some toxic gel on a doorknob, then it's gone too far and it's violated enumerated powers. But the court halted and didn't go quite that far. Instead, they used its power, as the court often does, used its power to construe the statute, to interpret the statute in a way that avoided any kind of possible constitutional conflict. Of course, going back, as we've seen several times, to Justice Brandeis's doctrine of constitutional avoidance and the Ashwander rules. Well, that's at least a brief entree to the treaty power and federal supremacy, some of the issues that arise whenever we consider the scope of Congress's powers under the treaty power, and how that interacts with the whole doctrine of delegated powers, how the treaty power perhaps expands federal power, but also how it's limited by the prohibitory terms of the Constitution. But thank you very much for your time.